So very good morning everyone. Today we are going to tackle and complete General Clauses Act. Let's not postpone to another session. Okay. Full session we are going to take. First our target is to complete a 12 marks area in law, which is the General Clauses Act. Okay. So some points on concept is pending. I will revise once everything in General Clauses Act. Once completed, we will go into that particular part. Once that is also completed, we will give a full stop to the General Clause Act by completing question bank discussion also in the today's session. Okay. Please pass on the message about the class to everyone, please. We'll start in 2 to 5 minutes. Ask everyone to join. FM, as I said, we are going to have from 15th for around 9 days, 7 to 8 days, 9 days. In that segment, we will complete all the chapters. Okay. If you have already completed the chapter, that day you need not attend. Every single day, one chapter we will try to complete there. Fast everyone. Please join fast. Shall we start? Okay. See here, General Clauses Act. Today we are going to complete that particular act. First, that is our target because it's a 10 marks to 12 marks area. So we will complete the concept as well as the question bank discussion in the today's session. All kinds of unique questions, wherever they are tested, we are going to cover every point. Okay. So first one, with regard to the General Clauses Act, I will do a very quick revision, 10 minutes. Those who did not follow previously, please follow at least now. After that, I can't do anything. So point number one, General Clauses Act, first introduction. General Clauses Act will contain the general definitions. Okay. If any word is not defined in any other act, it will be defined in GCA. What is the territorial applicability of GCA? Whatever is the territorial applicability of a central act, to them this GCA will apply. If central act is applicable to entire India, GCA is also applicable to entire India. Next, what is the objective of this act? Firstly, various acts like you need not define the same word and increase the language. In one act called as GCA, they define some terms. Those terms, wherever they are used but not defined, you can use General Clauses Act. Next one, because of that, wherever, if there are 100 acts, example, 100 la 30 acts la already words are defined. In 70 acts, words are not defined. What to do? All the 70 acts uniformly will come to General Clauses Act and refer to that definition. Uniformity. Next one, not only definitions, GCA also contains rules of interpretation. How to interpret singular, how to interpret plural, how to interpret the word from, how to interpret when there is a court holiday. All these things will be defined here. Already we discussed in the last class. Okay. So if there is any act where by mistake, any oversight or by slip, if any word is not defined, you can come to GCA. Next one, what is a bill and act? Bill before it is passed in the parliament, okay, it is called as a bill, and bill once passed in the parliament becomes an act. Next, then president approval, official gazette. Definitions. Government definition, central government, state government. Central government means what? Before constitution, governor general. After constitution, president office. Act here, not Companies Act, GST Act. Act means an activity. Activity also in a negative terminology. Therefore, act for a civil wrong or an offense, okay, will mean not only the series of acts done, but also the omissions which are made illegally. Okay. Next, what is a rule? Rule made in exercise of power conferred by the enactment. Enactment means act. Their act, when the draftsmen are writing it, they can't do everything. They will tell this is as may be prescribed by MCA. As may be prescribed means whoever is the governing body of that act, they will take care. Okay, they will be conferred with the powers of the enactment. Commencement. When an act will be coming into force, when an act or rule or regulation, when you will tell that it is coming into force, okay, the day on which it is coming into force, that day we will treat it as a commencement date. And when the act idea started, when the draftsman completed, when it is a bill, when it is put in the parliament, when it is passed in the parliament, when the president approved it, all these things I don't want. Okay, when it is coming into force, how do I know when it is coming into force? Official gazette they will write. If you write in that official gazette, very good. If you do not write, yesterday we already discussed, president's assent date will be treated as date of commencement of an act. Next, financial year. Financial year means an year which starts on 1st of April, ends on 31st March of next year. Year, calendar year, Jan 1st to December 31st. Person includes company, body, corporate, or association of persons, body of individuals. Next, immovable property. Very, 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 very important definition. Example 7 times the question came. So please listen one more time. Immovable property, okay, includes land, benefits arising out of land, things attached to the land, permanently fastened to something attached to the land. Okay, but very, very important thing here. Immovable property does not mean only the land. It includes a land. Okay, for example, building, immovable property. Sir, where is the building, sir? Land, benefits out of land, things attached to land, all these things you said. Where is the building? Building is not attached to land. Building is constructed on land. Where it is? It is in this includes. Okay, the word used is not means, the word used is includes. So immovable property includes land, benefits arising out of land, things attached to the land, or permanently fastened to anything attached to the earth. Okay, this is what we have understood. Okay, one exam question is there. I will show you. It will give a different thought process of understanding immovable property. That's why I'm not revealing that question now. We will see. Movable property, anything other than immovable is movable. Next, document. Very, very important definition. Document is imported from Indian Evidence Act. Document includes what? A matter which is always written, expressed or described on what? On era, on a substance. Okay, by using what? Letters, figures, or marks. Okay, next, marks means not 75 marks, 100 marks, marks, tick marks, or into marks, like that. Okay, which is intended for recording that matter. Okay, currency notes will not be treated as a document. So what is a document? Document includes any matter written, expressed or described on a substance, using what? Letters, figures, or marks, which are intended to get recorded. Next discussion, we went into the concept of imprisonment. Imprisonment is done as per Indian Penal Code. Okay, Bharatiya Nyaya Samhita, like that they changed it now. Now they made Bharatiya Nyaya Shiksha Samhita, like that. So now BNSS, all these things came, but originally they call it as a Indian Penal Code. So imprisonment means what? Imprisonment means any imprisonment under the Indian Penal Code. Under Indian Penal Code, there can be two types of imprisonment: rigorous imprisonment, simple imprisonment. Simple imprisonment concentrates on isolation. Rigorous imprisonment concentrates on isolation plus hard bound labor. Okay. Next, official gazette. State issues na state gazette we call. Central government issued na Indian gazette we call, or Gazette of India. Okay. Next, affidavit, oath or swear. It's a declaration. First word what institute will see na affidavit question or oath question or swear question comes. It means, it includes affirmation or declaration, affirmation or slash affirmation or declaration by persons. Affirmation means what? I am firmly believing it. Declaration means what? I am declaring it. Both are having same language. Okay, it includes an affirmation or a declaration by persons. Affirmation or declaration by the persons allowed to affirm or declare. If I was given a chance to affirm, some other person should not declare on my behalf. So that's why what is the language used? It includes an affirmation or a declaration. By whom? By persons who are allowed to affirm or declare instead of swearing. So I told you, if you wanted to swear, you need not oath and declare, affirm. If you affirm, you need not do the remaining two. So already we discussed that in the last class. Can be used as evidence in the court. Affidavit to oath, swear have a same definition. Next, very important, another one is good faith. First thing that we have to understand in good faith is anything done honestly is a good faith. Good faith equal to honesty. So anything done in good faith, if it is done honestly, whether you have negligence or not, remove. But honesty is the most important. Honesty means what? I don't know that this will happen. Normally I have done. Okay. So anything done with due care or attention, which is not malafide, is presumed to be done in good faith. Good faith is defined differently in different acts. Okay, this definition does not apply to enactment which can, that already we know now. If a particular act already defined the term good faith, then General Clauses Act concept does not apply. Classic example, Indian Contract Act. Indian Contract Act, okay, what they said, na, as per Indian Contract Act, an act is said to be in good faith if it is done without, okay, if it is an act is not said to be done in good faith if it is not done with due care and attention as expected. So what is the most important thing that is required for good faith? Good faith ki first important is due care, attention. Already I have written an equation on the last day. So good faith means honesty, due care and attention. These three words you have to write in exam. You will get the 2 marks. So an act is said to be done in good faith if it is done honestly with due care and paying attention. Then we call it as what? Good faith. Called as what? Good faith. It is same in all the acts, different in different acts. If a different act defines good faith, follow that. If not, follow this. Next one. How to understand whether a person has done a good faith or not? It depends on the facts and circumstances of each case. Exam questions when we do, you will understand how they will ask the questions. Very important. Next one is coming into operation. Coming into operation. When a particular act is said to be coming into operation as per the official gazette. Okay, if official gazette it is not published, then the date on which it obtained the assent of the president will be treated as, okay, Governor General previously before Constitution, or else President, that day will be treated as coming into operation. Next. This point you can read. If an act empowers, this I did not discuss in the last class, let us read. I forgot actually. If an act empowers government to bring the provisions into operations on a day it deems fit, court cannot issue mandamus. Mandamus means a order to the government to bring it into operation on a particular day. I will give you an example. See, there is an act. In that act, when this act has to come into operation, it will be said in section 1. Section 1. Section 1 of Companies Act, if you see section 1, subsection 1, clause C, if you see Companies Act, they will tell this act comes into force on so and so date, like that they will tell. Correct? So like that, act has given power to MCA there. At a Companies Act, when the lawmaker is drafting it, they gave power of bringing into existence of any section to the MCA. And they said, MCA, you decide when a particular section has to come. Therefore, what MCA has done in Companies Act case, they brought 98 sections. How many? 98 sections on 13th September 2013. Okay, 13th September 2013 ki they brought how many provisions? 98 sections they have brought. Okay, next what they have done, 1st April 2014 ki 182 additional sections were brought, and already 98 plus 198, these two sections were brought. Later another 70 sections came, later another 30 sections came. And who is bringing all these? MCA. Who gave power to MCA? Act has given the power. Are you understanding? Now listen carefully. Companies Act, they clearly said it will come into existence as may be prescribed. And a rules government has to bring the sections. Uh, Lawmaker drafted all 470 sections of Companies Act. My work is completed. Now, when to bring that into existence is in the hands of MCA, because law has given powers to MCA. Okay. Now can court involve into that and tell MCA, bring all these sections, this set of sections on 1st April 2014, like that can court tell? Court cannot involve into that. That's what he wanted to tell. See here. If an act empowers government to bring the provisions into operation on a day it deems fit, court cannot issue a mandamus, means order, to the government to bring into operation on a particular day. It is general. Now listen to the concept. Companies Act was brought. What was brought? Companies Act was brought. Okay. There are 470 sections in Companies Act. Listen carefully when I am discussing something. Okay? Please. Companies Act లో 470 sections are there. 470 sections la 98 sections were brought into existence on 13 September 2013. 182 additional sections were brought on 2014. Like that, continuously over a period they have applied the sections. Okay, now listen carefully. There is sections relating to some offenses, okay, which were not yet brought into existence. Unfortunately, these are not there in 1956. Sorry, to go back and at least punish them under 1956, 1956 that section is not there. Classic example, Companies Act, there is a section called as insider trading. See a final. Insider trading. That was not there in 1956 Act. Brought into 2013. But that was not brought into the first 182 and 98 sections. People started doing insider trading. What is the confidence? Anyway, Companies Act came into existence, but government did not bring these sections into operation still. They said 98 and 182. In that, insider trading section is not yet operated. Therefore, what people started doing? They started doing insider trading, telling that we are not punishable. Act section is not coming into operation. They said punish under 1956. 1956 Act section is not there. Problem started. Therefore, do you know what happened in Companies Act? Court has passed an order to the central government at that time. At the issue it made, it was made a very big issue at that time. So Supreme Court passed an order to MCA saying that, "Are MCA, are you sleeping? Bring that section into operation first." Which one? Insider trading related section. People are happy, jolly that they are doing it. So bring into operation. Like that, court can question why you are doing a delay. Law gave you power to bring a section. You should use that now. You are not using it. People are doing misuse of the provisions. Therefore, try to understand what they wanted to tell. But if sufficient time has elapsed since act or provision is passed, provision here, and it is not brought into force, court through a writ, okay, at a written order. Writ is a shortcut for written. So writ means a written order, can direct government. They cannot directly bring. Like I said, they said to the MCA directly, "Are MCA, consider the question to bring into operation." Bring that into operation. Yeah, people are doing insider trading. Jolly they are doing because there is no punishment for whatever they have done. So, whenever act empowers government to bring something into effect, government only have to bring. The court cannot involve or interfere or pass a order. However, enough time has been elapsed, but still the provision is not coming into operation. It was misused by public. Court cannot be a silent spectator. It will pass a writ order on the government and it will ask them to bring it into operation. Okay. Next, sir, an act was brought on 31st of August, sir, on at the time of 3 o'clock in the afternoon. Okay, will the day be counted? That's why, see, law takes no cognizance. Cognizance means knowledge of. Fraction of a day. Fraction of day. So, if an act was brought on 3rd, okay, so that's why fraction of days will not be counted. It will be treated as a full day. If act comes into force on 1st January, it will come into force as soon as the clock strike 12 on night of 31st December. Okay, this is the point. So read up to here once. This concept we did not cover in the last class. By oversight, I did not see. Now see, revision how it helped you. First of all, everyone give a reply. 20 minutes, I am only shouting. You should tell whether you understood or not. Okay. Whoever is having the charts, please read. I'm giving you exactly 3 minutes of time. Why I'm giving time? Today we are going to do question bank. At that time, I don't want wrong answers from you. You read this? Read this page also fully. I'm again telling those who are not attending live, please do not blame me after once the live was taken out. Every day I'm reconsidering your words. Read this. Today we are going to do the question bank, please, everyone. get a full control over and grip over the chapter. We start with the repeal revision. Okay. See here, we are going to discuss about the effect of repeal. So what is the repeal? Repeal means complete obliteration of an act. These are the words study material has used, and you should also use the same thing, or else marks will not be given. So first, what is the repealment? Repealment and deletion both are not same. Okay. A repealment means obliteration of a provision or a particular act itself as if it were never existed. Okay, as if it were never existed, and affects rights and cause of action relating to the repealed provision. Okay, means once an act is repealed, that's it. That act will never be again referred back. Okay, classic example, Companies Act 1956 was repealed by Companies Act 2013. Okay, so main point that you have to understand is, see, whenever one act is repealed means always you should remember repealment will substitute it. Deletion or substitution need not happen. Means what? Whenever a particular act or a section is deleted, that section is omitted. That's all. Sometimes replacement may be there, sometimes substitution may not be there also. So what is the point? Repealment will always affect backdated. And what does it mean? Companies Act 2013 came into existence, and Companies Act 1956 is closed, repealed. Okay, means once a Companies Act 1956 is closed completely, once it is repealed by Companies Act 2013, even companies incorporated in 1956 Act also will get applied with 2013 Act. Means we will not tell that from here to here 1956 Act will be followed, from here to year 2013, like that it will not be. Once 1956 is repealed, we will take into existence as if it were never made. Until Companies Act 1956 concept not there. Okay, only 2013 Act is there. And whatever the previous company laws are there in India, okay, 1866, 1881, 1913, 1942, 1956, those all are repealed. Means what? We will think they are never existed in this world. Okay, they are dinosaurs, they are extinct. We think that they never existed. Understood? We think that they were never existed. Like the 2013 will be read. That's why even companies incorporated under 1956 Act, because of repealment of 56 Act, 2013 only will apply to them. Are you understanding? So therefore, repealment relates to a complete obliteration of a provision backdated as if it were never existed. Okay, as if it were never existed. Next one, deletion is not like that. Deletion ke past date effect will not be there. Okay, deletion effect from the date of deletion and is not total wiping out of provision. Okay, and what does it mean? For example, today is, let us say for example, okay, today what is the date? 8th July. So 8th of July 2026, let us say for example, there is a section called as section 10. This was deleted. Okay, once this is deleted, from today onwards this section is said to be deleted. Okay, if any issue relating to section 10 comes on 7th July 2026, still it will be operational in the court. Okay, still it will be operational in the court. Why it will be still operational in the court? Because this was a deleted section but not a repealed one. Once a section is repealed, we will have an effect as if it were never existed. Deletion will affect after that. So deletion will have prospective effect. Prospective means futuristic. Repealment will have retrospective effect. Retrospective effect means what? I will go back and then I will delete it. Okay. So, however, don't think in a different way. And people think like this. Oh, and repealment means what? Repealment means completely we will obliterate a particular provision or an act as if it were never existed. Okay, as if it never existed. So as if it were never existed means whatever liabilities that I get in that old act, I need not pay them. That's why effect of repeal. If an act repeals any act, if an act repeals any act, repeal cannot revive anything not enforced during the period of repeal. Okay, revive means bring back anything not enforced during the period of repeal. Means repealment once happened. Okay, repealment once happened. One act repeals another act. One act repeals another act. That's it. That old act completely wipes out and new act will come into picture. Old act provisions cannot be revived back again. Number one, it cannot affect the previous operation of a repealed enactment. It cannot affect the effect of previous operation of a repealed enactment. Repealed enactment before already something has happened. Those things won't get affected. Next, repeal cannot affect right, privilege or obligation or liability under the repealed enactment. Repealed enactment you have to pay a penalty. You have to pay that. And just because of the reason that repealed enactment will be treated as if it were never existed, your penalty never existed, we will not assume. Penalties, forfeitures, punishments, inquiries, litigations, all these will continue even if an act is repealed. So repealment you should see in two angles. Repealment technical sense, repealment in logical liability sense. Okay, repealment in a technical sense, how we need to understand? When something has been repealed, when some act has been repealed, what will happen? Act will go away. We will think as if it were never existed. But for limited purposes, we will consider it. Limited purposes. Now, what are the limited purposes? Number one, rights and privileges. Number two, penalties and punishments. Number three, liabilities and obligations. For these purposes, repealed provisions will still continue on you. Okay. So that's what example was also given. A company incorporated in 2012 under which Act 1956. Okay. Act is still valid. Any penalty imposed in 2011 under 56 Act remains enforceable under 2013 Act also. Okay. So 2011 law under 1956 Act, one person is imposed with penalty. Court law, it 1-2 years completed, it is still going on. Okay. It still remains enforceable. Next. If a case is filed in 2010 under 1956 Act, it can be still continued in the court. It can be still continued in the court. So that does not mean repealed act went na, your liability also gone. No. Repealment law will go, but effect of law will still continue. Next. Other provisions for repeal. If an act repeals and reenacts any provision of former act, then reference to the repealed provision in any enactment is considered to be reference to the enacted provision only. For example, if an act repeals, Companies Act 1956 is repealed, okay, and reenacts any provision of former act, 2013 Act came and they reinforced, let us say section 571 of Companies Act 1956 still applicable, they said. Then whenever I use the word Companies Act 1956, that does not mean all 700 sections of 1956 Act. Only the reenacted repealed provisions we are giving the reference. Next. Now we are going to read general construction provisions. Okay. Time commencement from exclude the first day to include the last day. Computation of time. If a thing has to be done on a particular day in a court and court is a holiday on that day, you should take the very next day. That itself is a compliance. Okay. Next. Measurement of distance. Horizontal plane on a straight line. Next. Gender and number. Words denoting the masculine gender to be taken as feminine gender as well, unless and until there is a repugnancy. And I really intended to cover only women, then women does not mean men. Or I wanted to intended to cover only men, women will not be covered. Words in singular generally mean to take also plural, unless the context otherwise require. Okay. On this I will show examples also when we come to the question answer discussion. Next. Duty to be taken up in pro rata. Means when pro rata taxation comes into picture, these many cages ki this much of tax means if I have some number lesser or some number more, pro rata basis you need to pay the duty. Next. With this we completed 30 minutes complete discussion. I have repeated everything in General Clauses Act for you. I don't know how many of you have followed. First tell me, shall I continue now? 35-40 minutes I spent to revise because General Clauses Act, people are not even writing properly in exam. Flop they are doing in exam. 10, 12 marks General Clauses Act, they are getting 1 mark to 2 marks like that. Okay. Okay, done. Power and functionaries. Now let us read section 14 to 19. 14 to what? 19. Okay. See, power and functionaries. Section 14 to 19. One by one, let us understand and complete it. Exam tested many number of times. Next one, we will read this provision as to the orders, rules, etc. made under the enactments. Miscellaneous sections will apply. Okay, miscellaneous sections will apply. Once these are all completed, we will be done with this chapter. We will go for question bank discussion. Okay, let us begin. Power and functionaries, section 14 till section 19. Powers conferred to be exercisable. If any power is conferred, that power can be exercised whenever required. See, I will give an example one by one. Conferred word is used in law. Conferred means to give officially. Police has been given a power to arrest. He is conferred with the powers to arrest a person. Okay, that does not mean he can arrest anyone at any time. It means whenever required only that power has to be exercisable. Whenever I say the word power given, power always associates with the word may. Okay, not shall. People will think this way generally. People, in the sense, generally, students' sake, if you want to understand, generally, what student will think? Power. Power means shall. Power is always a may. What do you mean by power is always may? When I give you a power to do something, you may either do that power, you may exercise that, you may not exercise. Always the word power is associated with the word may, not with the word shall. So mark these words clearly. So powers conferred to be exercisable. If any power is conferred, that power can be exercised whenever required. So whenever required only you should see. The word important is required. Is there a requirement to exercise that? Then you can exercise, or else you should not. And just because of the reason that I was given with the power, I cannot exercise even though requirement is not there. That you should not do. Misuse of powers it will become. Okay. Point 1 over. Point 2. Power to appoint include power to appoint ex officio. Sir, what is this, sir? I will explain. If the power to appoint a person is conferred, then appointment may be made either by name or by virtue of the office. Read it first. I will explain with a very good example. Okay. Have you read or not, everyone? Let me know first. I hope you might have already read this for 2, 3 times now. Okay. Now you do one thing. Also read the next one. Power to appoint include power to suspend. First one is power to employ include power to appoint ex officio. Now power to appoint include power to suspend. Read also that authority having power to make appointment shall also have a power to suspend or dismiss any person appointed by itself or other authority. Okay. Read those 2 points. Okay. Shall we begin analysis? Okay. Yeah. Listen. I have given enough time here. Around 3 to 4 minutes time I have given for you to read. Listen. Power to appoint include power to appoint ex officio. I will explain. Please listen carefully. See, state government wanted to form a committee. State government wanted to form a committee. See, state government wanted to form a committee. What committee? It wanted to form an industries committee or industrial development committee. Committee members are required na? They can tell like this. So who have power? Power to appoint officers in the committee is there to the state government. Okay. Now what they are doing now? See, state government formed a committee which is called as a industries committee. In that committee, advisory members are required. Okay. They said members are like this. Mr. A, Minister for Urban Development. He is one of the member. Okay. Mr. B, a renowned chartered accountant for giving advisory. Mr. C, chairman of Textiles Board. Chairman of Textiles Board, Andhra Pradesh State. D, or like this they can tell. A, B, C, next one, they said chairman of SIRC ICA. Okay, SIRC ICA. Next, district collector. District collector. Next, IG Police Department. IG Police Department. Listen, the question what I have given you is tested in CS executive exam. Ditto question Small changes they made that I did not remember, and whose names were given here. Okay. Now listen carefully. These are 2 marks question that came in their exams. Here, do you know what is the point you need to remember? State government is forming a committee. Industries committee. They wanted to have members with them. They can appoint members in this way. They can tell name of a person, Mr. A, Mr. B, Mr. C. This is called as what? Appointing a person directly through his name. Next, chairman of SIRC of ICI. This fellow will change every year. Chairman of SIRC of ICI means what? He will be there for a lifelong. If you are SIRC chairman, you will be the chairman for throughout life. No, the term is for 1 year. After 1 year, another person will come. After that, another person will come. So it is a changing office. Okay, it is a rotatory in nature. Those who are chairman now will not again become chairman in the same branch again. Na? So therefore, what is the point? Committee has to continue for 10-15 years. Okay, if I, for example, I never had an idea to go into ICA, these committees and other things. Example, Kaushik Mukesh is the SIRC chairman sitting in Chennai. Okay, how many years Kaushik Mukesh will be the chairman of SIRC? 1 year. Next year, he will change, some other person will come. After that, some other person will come. Therefore, if I write here the name Kaushik Mukesh, whenever Kaushik Mukesh loses the office of SIRC, again you have to change the committee. Therefore, instead of writing like that, sometimes instead of writing the name of a person, they will write the name of the office there. Okay, that means he is already holding an office. X office. X office means already means X. See, X president means what? Previous. And ex officio means previously you are holding an office already. Which office? SIRC chairman I am. Okay. By the name of that office, I will write there in the committee. And whoever will be there as a chairman, he will be he is forming part of the committee. So sometimes names can be given. Sometimes if names are not possible, I will give the reference to the office what he is holding. Whoever comes into that office, he will be taking care of that particular thing. So chairman of SIRC of ICI means what does it mean? This time KM, next time some PM, next some DM. Who will come? That person will be the committee member. District collector also same. Your life is not permanent there. You will change. So district collector is a committee member. Okay. Now district collector can be Mr. A. After 3 years he can be Mr. B. After 1 year it can be Mr. C. Anyone can be there. Whoever comes as a district commissioner or district collector, he will come into picture. IG police department, same thing. Inspector general should become one of the member because he will be knowing about public affairs, everything. He should be forming part because he is an IPS. So I want one person from IG police department to form part of our industries committee to talk with all the people, etc. Police force is required. I want IG police department to become the member of a committee. This is also again changing office. This is called as ABC appointment by name. This will be appointment by X office. Everyone answer. You understood the point clearly? Yeah. Fast. Very bad response. Fast. I always tell you, I know about students very clearly because I'm not a damn bloody fool after seeing. See, when we started the classes, the graph will be like this. Slowly, student concentration will come down like this. Some students will maintain here itself. These are the students who will qualify the attempt. I'm really telling you seriously. This falling concentration will be there. They tend to lose concentration. They tend to lose the perfection as well. Slowly gone. This is the secret of success, a consistency. How consistent you are in learning, that consistent you will be writing the exam. First, super people will listen, slowly come down. But those who are participating live every single day, I can see at least 20-30 people every day. Undoubtedly, I am telling you, you will qualify in the September exam. Mark my words. You will put me a message. Sir, I qualified CA Inter. You will only put me a message. I qualified CA Inter. You will definitely qualify. Consistency, yeah, you are consistent in doing something. Consistency gives results always. So who are less consistent na? Result is also unguaranteed only to them. Again they will write, again they will write. Till they are consistent, result won't come. Mark my words. See, power to appoint include power to suspend. Power to appoint include power to suspend. So, if power to appoint to some person is given to another person, obviously when I have a power to appoint him, I also have a power to remove him. Correct? Ah? Okay. Now listen carefully. See, if we start discussing Lana, we can go and dig a ocean directly. Okay, you should mark my words. You can dig a ocean. We can create a ocean in itself in learning. I will show you an example. Maybe you can understand it. Companies Act I opened. Okay. Now I want you, every one of you, read this section. Mainly the important lines are, read this. Who will teach law with the final questions, CA final sections, the reference? We are doing so much of efforts now. That efforts will reflect in your success always. Take your life seriously. Don't hurt your parents. Why we are doing so much of hard work? The CA final classes are getting started. That's why morning class, all these things I need to change a little bit, because that's a paid classes now. They will definitely argue with me, sir, you're taking free classes in domination to the final paid classes. So like that, they will shout. Their point of view is also correct. So that's why I'm making alternative arrangements for you now. I'm not just telling we'll stop the class. We'll have alternate arrangement. We'll cover. Promise is always a promise. It has to be committed. And I promised you that I will be there with you till September you write the exam. And I am completing the syllabus by August 6th, 7th. We will complete everything. We'll do revisions. We will do all things once we complete now. Again, we will revise everything. I said I will be with you till September. My word is a word. That's all. There is no change in that. Till September, I said I will be with you. Till September, you write exam, I will be with you. No doubt, no second thought. Read, 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 read. Read, 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 please. Read. You can send me love hearts later. Please read this. Read, read. I have a very important point. A lot of things to discuss here. See, if you read section normally, in 1 minute it will be completed. But if you take examples and read, the torture starts. Have you read 161 subsection 1 or not, everyone? Have you read subsection 1 of 161 or not? Now I will ask questions, okay, on that. I will put the bare act before you. You just read and tell, okay? Number one question. Which directory is referred in the section 161.1? Start giving the answers. Which directory is referred in 161 subsection 1? Which director? Fast, please. Board of directors. Ray, listen to my question first. Kekda, everyone. Are you listening? Managing director. Hey, see the question here. What I am asking here. 161 1 la which director we are discussing? Which director? Okay. See, additional director. Which director here? Additional director. So which director is referred here? Additional director. Okay. Sorry, 1 point over. Now second question for you. Who will have a power to appoint additional director? Start. Who will have a power to appoint additional director? Who will have a power to appoint additional director? I repeated the question for 3-4 times. Who will have a power to appoint additional director? Super. Super. Shareholders and board of directors are illa, wrong answer. Where it was said that shareholders in a shareholders in this one, they just said he will continue office till the AGM. That's all. Shareholders are not involved. Board of directors will be involved. So board of directors will be board will get powers from article. That is okay. So who has the power to appoint? I'm not asking who is giving power to board. I'm asking who has the power to appoint. Okay. So board of directors have a power to appoint. Okay. Now let's come to the General Clauses Act. Power to appoint include power to suspend. Authority having a power to make appointment shall also have a power to suspend or dismiss any person appointed by itself or other authority. Means what? If authority is appointing a person, same authority will also have a power to suspend or dismiss him and removal. Correct? Now you tell me from the additional director point of view. Additional director appointment and removal. Okay? You tell me. Who will appoint additional director? Who will appoint additional director? Very good. Appointment is done by board of directors. Very good. Appointment is done by board of directors. Super. Next. Then by applying the rules of General Clauses Act, what you have to understand, when additional director appointment is made by the board of directors, though not said in the section, removal also will be done by whom? This is missing block. Missing block we have to fill using General Clauses Act. So now tell me, who will have a power to remove? Yes, very good. So power to remove is also with the board of directors. Power to remove is also with the board of directors. Why power to remove is also with the board of directors? As per the provisions of General Clauses Act, if an authority is having a right to appoint or power to appoint a person, not just appointment powers are given to them, they also have a power to remove them, suspend them, or dismiss them also. Understood? So this is as per General Clauses Act. Wrong. Like this, you should not think. That's why this example was taken. See, wrong. This answer is wrong. Sir, just now you said, no, sir. Power to appoint if it is given, power to suspend also will be there. But you forgot about the objectives of General Clauses Act. General Clauses Act will apply if a specific act is silent on anything. Okay. Specific act, if it is silent on anything, General Clauses Act comes into effect and operation. Understood? So, General Clauses Act, when it will apply, if a specific act fails to say something, generally I will apply the provision. specific can never be taken a lesser priority than general. If the act, Companies Act specifically, if they say anything about removal, now follow that. Don't apply General Clauses Act. Board of Directors will have a power to appoint additional director. How to remove additional director is not given in Companies Act. Now, then GCA you can go. Okay. See, I will show you the section. See. Removal of directors, 169. Removal of directors, section 169. Removal of directors, section 169. The company may, by ordinary resolution, remove a director. And who should remove? Shareholders should remove. Board cannot remove the directors. And what is going wrong? Your general clauses rule is wrong here. Why? Because specific act already they said how to remove them. Now do you understand the difference? Huh? Who will know this? If you teach inter and final, all these sections will come. Linking is possible only when you read entire 470 sections of Companies Act, not just from up to 148 sections of CA interfered. Now you won't understand. 470 sections, if you have clarity on Companies Act, interlinking becomes very easy for you. Okay. So therefore, Adi General Clauses Act applicability. And how to understand the applicability of General Clauses Act? It is general. Means if a specific act fails to define something, then come to General Clauses Act. Don't come to General Clauses Act if the specific act is saying something on that. Okay. Next. Official chiefs and subordinates. A law applicable to chief or superior of an office shall apply to deputies or subordinates performing duties in the place of their superior. See here. I have given one example. X, director of DGCA. Okay, director of DGCA went on a leave, and during this time, X, his deputy, handled his duties. Powers and duties assigned to X is validly extended to Y, and all actions taken by Y would be valid. Lead. See, I will give an example. There is a CM. This CM is going on a visit to some country X. Singapore, Malaysia, no, Japan, no, or some country. He is going China or USA, something. Now, in his place, deputy CM can act. Okay, provided he is not a waste fellow. Okay, provided this deputy CM should not be a waste fellow. If he is a waste fellow, no, nothing we can do. Okay. So, if this fellow itself is a waste fellow, okay, unwanted fellow, then we can't do anything. But if he is really worth holding the office of a deputy chief minister, he can act on behalf of the CM. But what rights you will have, what powers you will have, what liabilities you will have the same rights, powers and liabilities like that of the chief minister. Do you understand the point, everyone? Everyone answer, yeah? So that's the meaning of the deputy. Deputy means one level below this fellow, he is called as a deputy. But a deputy should not be a dog. Deputy should be a human being again. Hey, you understood, everyone? Deputy should not be a dog. Means if a main person biscuits if they throw, he should not eat. He should have his own identity. Clear, everyone? So, X, a director of DGCA, went on a leave. During his time, Y, his deputy, handled his duties. Now, you are a deputy, not real, but you are now handling his office. Same power, same duties assigned to X will be extended also to Y. Okay. all actions taken by Y would be valid. Ante if deputy holds the office of, if a deputy holds the office of the main person, then he will also draw all the powers and liabilities of that office. Okay, provided I gave the example now, you can understand it very clearly. Those who understand will understand. So when you have the power now, that power should be validly extended. See, CM case some powers are not there. Deputy CM cannot tell anything. Are you understanding? See, if CM has a power to do something now, deputy also can do. For example, there is a ship coming from ocean, a wrong ship is coming, you cannot tell seize the ship. Are you understanding? You cannot tell seize the ship, that is not within your powers. Yeah, that becomes cinematic again. You should not do cinematic, you should do like normal person. Understood everyone? And basics also, if you don't know, then you will do such over actions. Everyone clear now? So this is a point. So whenever law is applicable to a chief, his subordinates, when they exercise his office, then they will also get the same powers and duties. Okay, yeah. Examples super. Life examples na, they always be super. The real life examples, sometime if you take na, that will connect properly. Those who understand will understand. So next, substitution of functionaries. Hey, these two are important. Yeah, exam can mark them important. One question can come in exam. Expected question this time. Expected question this time. Okay. For indicating application of law to a person executing the functions of an office, it is sufficient to mention official title of officer executing the functions or officer who commonly executes such functions. Successors. For indicating application of law to the successors of functionaries or corporations having perpetual section, it is sufficient to express application to the functionaries or corporations. Okay, take time. I will explain the examples also. First, you read it and understand. Read 1 2 times, or else you can't understand. Okay, can I continue? Can I continue? Okay. Hmm. Let me explain what is the purpose. Please listen carefully. You can't understand if you don't listen. Please, the first key point is these two are expected questions in the coming exam. When I say expected question, we will take a lot of time to understand it. Okay. That's why I made full screen also. I will write down. That's why I will explain you. First point number one. Substitution of functionaries is the point first. Substitution of functionaries. So first question will come. Okay. Sir, what is a functionary? What is a functionary? Functionary is a person who is having authority. Authority to do what? Authority to exercise powers and functions. Okay. District collector is a person having authority to exercise powers and functions. District collector is a functionary. So first point completed. I will summarize everything and I will explain. Okay. See, examples of functionary: district collector, commissioner of income tax, ROC, okay, election commissioner. All these are examples. Number three. Okay, number three. Emphasis and importance. When I say district collector, when I say commissioner of income tax, when I say ROC, when I say election commissioner, emphasis is on what? Emphasis is not on the person, emphasis is on the office held by the person. I'm saying district collector, not Mr. A being a collector. A will come, A will change, A will die, A will live, A will be removed, A will be continuing. That I don't want. I wanted the office, not the person. So emphasis is not on the person, but on the office that he is holding. Okay. So one point completed. Next. What is the need for the section? What is the need for the section? Okay. What is the need for the section? See, law is drafted to last for decades. Law is drafted to last for decades. Means it is not for 1 day or 2 days or 1 year or 2 years. It is meant to last for decades together. Okay, that's the first one. So what will happen? Officers will retire or they will be transferred. Okay, government departments will change, designations will change, authorities changed or abolished completely sometimes. Okay, whenever changes in administration is made, law cannot be amended because it becomes very difficult. In order to tackle this, substitution of functionaries came. Read this document first. I tried to put all the points in my mind in the form of a statement. Have you all written somewhere? Read this, read this. Okay. See, what is the main crux of this concept? Now, let me now explain. See here. Now, Mr. A is the district collector. Now, Mr. A is a district collector. Now, he was removed and Mr. B came into existence. Now, tell me, B changed, na? The district collector changed, na? Now, we have to amend the law again. What powers are given to Mr. B? Nothing, no need. Whatever the powers Mr. A has exercised, immediately once he is substituted, he will also exercise the same powers unless the powers are specifically altered. Unless the powers are specifically altered. I will give you an example. See here. See here, see here. Previously in Companies Act, there used to be a entity called as a CLB, Company Law Board. Company Law Board. This is a functionary where in 1956 Act, 2013 Act when it was made, this functionary was removed and the CLB is removed. In place of CLB, NCLT came into picture. National Company Law Tribunal came into picture. Yeah, okay. Now tell me what is happening. There is a functionary. That functionary is substituted by another functionary. Now what are their powers? Their powers I need not tell separately because they are substituting CLB now. What powers are given to CLB? Same powers are also given to NCLT. Everybody now understood the meaning of substitution of functionary. Yeah? For indicating application of a law to a person executing the functions of an office, it is sufficient to mention official title of the officer executing the functions. Means, what are the powers of Mr. A? Who is Mr. A? He is a NCLT president. What powers are available to CLB president? Same powers are available also to you, even when you substitute. So, if the functionaries are substituted, same powers of the previous functionary will be carried to the another person after him. Clear? Same concept as successor. Means what? District collector went out, Mr. A. Mr. B came. Who is Mr. B? Successor to Mr. B. Mr. A. A is the collector. Removed. B came. Who is B to Mr. A? Successor. What powers he will have? Same powers of the predecessor. For indicating application of law to the successor of functionary, okay, having perpetual section, it shall be sufficient to express application of functionaries or corporation. Means what power? Don't ask me what are the powers of Mr. A and Mr. B. Ask in which office they are sitting. Who is Mr. A? Collector. Now who is he is continuing a remove. Who came? Mr. B. As what? Collector. What are the powers of collector? So these are the powers of collector. That's it. Same is applicable also for the successor. Everyone understood the point clearly? Yeah. Everyone give a reply. Next. First I will cover miscellaneous provisions 25 to 30. Okay, 25 to 30 miscellaneous provisions I will discuss first. After that we will go to the remaining parts. Okay, see, first one, meaning of service by post. Meaning of service by post, mark this important expected question for the September exam. Meaning of service by post. If a legislation or a regulation requires document to be served by post, then the service is deemed to be effected. Effected means completed. If such post is properly addressing, prepaying the stamp value, posted by registered post. Means, see here, I will give an example. There is an act. In that act, they said that FIR copy has to be sent, FIR copy and charge sheet shall be sent to the accused, okay, through post. They said like this in a particular act. There is an act. When I am reading that act, in that act they said that accused and a person who is found suspicion of guilty, accused person is there. You have to send the FIR copy and charge sheet to him by post. They said like that. Okay, by post. Now, by post means how I need to send? Courier, speed post, what I need to follow? They said you send by any post, but it should satisfy 3 conditions. Address should be proper. Okay. Prepaying means what? Money should have already been paid at the post office when you are sending it. It should not be due. It should be paid along with the stamp value. Stamp you will attach on that one. Posted by registered post. Posted by what? Registered post. Note, a letter is considered as effected at time at which letter would be delivered in the ordinary course of post. See, generally from Hyderabad to Chennai, how much time a post will take? 2 days time. Okay, so whenever post, registered post, if I send from Hyderabad to Chennai, a particular post, registered post, we will assume that post has reached you within 2 days, and an ordinary course of postal, whatever the time that will be taken, that will be assumed. Next, if a notice required to be sent by registered post, acknowledgement due, is sent by registered post, presumption regarding service of notice by registered post under this section is not tenable. Sir, I did not understand. Listen, which act we are reading? General Clauses Act. Means what? If nowhere in the other acts they did not tell about anything, this will apply. For example, there is Companies Act. There is which act? Companies Act. Companies Act, they clearly said in a section that, okay, circulation of financial statements should be done to the members by the company by registered post acknowledgement due, not by general registered post. Registered post acknowledgement due means what? Do you know na? Registered post, normal registered post means what? You will register the post and you will send it to the person. It will reach him. Over. Acknowledgement due means post person will come to your home. If you are there, he will give to you. He will take acknowledgement from you. I received. Then only the completion of the post will be done. Okay. If you are not available, he will not give to any other person. He will go back. Again, he will come when you are available. He will ask your Aadhaar card, check the details, acknowledgement, and then only he will give you. So registered post and registered post acknowledgement due both are not same. For example, in a particular act, Companies Act, they said it should be sent to the members only by registered post acknowledgement due. You sent it. You sent by registered post. It reached the person. Acknowledgement is not done. Now post is done or not done? Not done. Do you know why? Sir, already registered post you said, no sir, General Clauses Act. General Clauses Act should be applied in general circumstances. There in that specific circumstance, they clearly said registered post acknowledgement due. So therefore, it is not properly sent. Okay. Next. If notice is sent by registered post to a person at proper address, it is deemed to be served in the due course. Endorsement not claimed or not made is sufficient to prove the service of notice. And simply to tell whether you received or not is not my point. Okay. If you are sending by registered post, not acknowledgement due. Registered post, if I send, I will see only 3 things. Whether address is proper, whether prepaying is done, and posted by registered post. That's it. Once it is all done, notice is deemed to have been sent. Why these all things came na? Court notices. Court will send notices. Court will send notices. Notices to whom? Public. They will tell, for example, there is an area. that area is illegally encroached and occupied by some people over a long 10 years. Court send them a notice. Please go out from that area. Government is going to construct a housing board there. Government, state housing board will be constructed. So you need to vacate, relocate yourself somewhere at the outskirts of the city. Like that, court sent a notice. These people won't listen to all those things. They will send, when you send me the notice, like that you will tell. That's why court always sends registered post acknowledgement due. And a post office person will come to that home. He will take acknowledgement also. Now you cannot tell to the court when I received the court notice. Are you understanding? So if it is a normal registered post, if I send to the person, perfect person with a proper address, it is deemed to have been sent. If notice is sent to landlord by registered post and it is returned by the tenant with endorsement of refusal, it is deemed that notice is served. Sir, what is it? See, there is a house owner. I am a tenant in that home. Example, my house owner is Mr. J. Okay, Mr. J. Let us say some name. Mr. J is the house owner. In that house owner's home, he is a landlord. I am staying there as a tenant. House owner received a registered post. Okay, house owner received a registered post. I opened the letter and I said that post office, I am not this person, gave back. Okay, he took back. Owner ki notice came. Tenant has took it. He refused to take because that is not me. Mr. J is my owner. I am K. So, therefore, I will not take it. Now listen carefully. The moment the tenant receives it, it is deemed that notice is served to the owner. Sir, I refused, even then, yes. That care should be taken by the landlord. Landlord should tell the tenant, tenant, if a notice comes in my name by a letter registered post, you take it. Like that, you should tell. Your mistake of not telling him will make you to suffer. Okay. Next. Provision as to offence punishable under 2 or more enactments. See, there is an act. There is an activity you have done, illegal act. Punishable under 2 different acts. Insider trading, I said the classic example. Insider trading is there in Companies Act, also in SEBI Act. Now question will arise, sir, I have done insider trading in a listed company, then SEBI la punishment is there, Companies Act la punishment is there. So I will be punished 2 times. If an act or a omission constitutes offence under 2 or more enactments, offender shall be prosecuted and sent to the court for all these procedures and punished under either of such enactments, not punished twice for same offence. Article 22 of Constitution states that no person shall be prosecuted and punished for the same offence more than once. This provision applies only if subject of prosecution of offence is same. If offences are distinct, this provision does not apply. For example, I did insider trading under Companies Act. It is also there in SEBI Act. I did misrepresentation under Companies Act. That is also there in SEBI. Now 2 punishments because the distinct offences you have done. Same offence 2 times I cannot be punished. And insider trading ki Companies Act 1 time, SEBI Act another time. No, either companies or SEBI. Do one thing. Next, misrepresentation ki either SEBI or Companies Act. You punish me. Now I am not punished for the same offence twice. I am punished for one offence once. So 2 offences you have done. 2 times you will be punished. In case of 2 charges in the same trial, if accused is acquitted from one of the charge, it does not bar his conviction on another. For example, there are 2 complaints on me under Companies Act. One complaint, the court said that I did not do. That does not mean other complaint also I am scot free. So for one complaint, you will be free. You will not be punished. For other complaint, you can be punished. Everyone understood? I want a reply from all of you. Next, recovery of fines. Section 63 to 70 of Indian Penal Code and provisions of Code of Criminal Procedure for issue and execution of warrant shall apply for fines imposed. That's not that great question, just remember. And always a fine is paid under these acts, Indian Penal Code and CRPC, Code of Criminal Procedure. Okay. Citation of enactments. Citation means a reference. An enactment may be cited by reference to title or short title or number and years, and provision may be cited by reference to section or subsection of the enactment. See, whenever whenever you see any kind of act, whenever you see any kind of act, brackets they will write number 49 of 2013 Companies Act Bear Act. If you see na, see the Companies Act Bear Act. Okay, this is Companies Act Bear Act. Companies Act Bear Act, do you know how it will be referred? Companies Act 8 see 18 of 2013, like that they will write. What do you mean by 18 of 2013? 2013 year la, this is the 18th act which came for applicability or amendment, either changes so new act or something. So in 2013 already 17 are done. Companies Act is the 18th one. Okay, so whenever you are citing an act, citing means referring an act, I can tell as per Companies Act, like that I can tell, or as per number 18 of 2013, like that also I can do. So citation of enactment, whenever you are referring the act, you can refer by title, the Companies Act 2013, or short title, you can tell New Companies Act, like that you can tell, or you can tell 2013 Companies Act number, you can tell years, you can tell 2013 Act, or you can tell either by reference number 18 of 2013, like that also you can tell number and years by reference to the section. Okay, next. Saving for previous enactments, rules and bylaws. Okay, rules and bylaws. Provisions of this act are for construction of acts, regulations, rules, bylaws made after commencement of this act and shall not affect construction of act, regulation or bylaw which is continued before the commencement of this act or are amended after the commencement of this act. Means General Clauses Act is applicable for any act that coming into operation after 1897. Before that, if anything is made and for that interpretations are already given, for that GCA do not apply. Simple points here, nothing great. Okay, so we now completed section number 25 to section number 30. All are over. So we completed 25, 26, 27, 28, 29, 30. So these are all completed in one set of chart. Okay, read it properly. In this, the most important one is service by post, expected question for September exam. Read it. Okay. So one person is asking to explain section 26 punishment under two acts. If same offense is punished under two acts, punish him either under any one of the acts. Okay. I did mistake under section number 10 of Companies Act and section number 45 of Companies Act. Both are again punishable under SEBI Act. Okay. Now two different offenses I have committed. Section 10 is section 5. Generally, I am telling section 10, 45. Now don't go to section 10 and see where is the punishment under SEBI. Just numbers I am saying. So you have done one offense under Companies Act that is punishable also under SEBI. Don't punish him under Companies Act and SEBI, either Companies Act or SEBI. Now I have done two offenses. One offense under Companies Act, another offense also under Companies Act. That is an offense under SEBI Act, also under an offense under SEBI Act. Now two different offenses are there now. First offense ki either Companies Act or SEBI. Second offense ki either Companies Act or SEBI. That's the meaning. Understood? Okay, done. Now we will go into the last part. Okay, see section number 20 to 24, provision as to the orders rules made under the enactments. Provisions applicable to making of rules or bylaws after previous publications. If power to make rules or bylaws is given, subject to it being made after previous publication, then authority having a power to make the rules or bylaws, okay, shall publish a draft of proposed rules or bylaws for information of persons likely to be affected. Along with the draft, a notice specifying a date on or after the draft will be taken into consideration shall be published. Publication shall be made in a manner authority deems sufficient as government prescribed. Authority shall consider objection or suggestion received on such a draft before specified date. Publication in official gazette shall be conclusive proof that rule or bylaw is duly made. It is open to such authority to make changes in the draft before finally publishing them. Also, it is not necessary to republish the draft rules in amended form before final issue if changes are ancillary or earlier draft cannot be regarded as foreign. Sir, one word also I did not understand, sir. That's why I am putting these provisions at the last. We will discuss that with good examples. First, read section number 23 from the chart. Read, or else you cannot understand. Exam lo question comes na duck out. Please listen carefully. Read it. Read. Take 2 minutes time. No problem. Read. First of all, everyone tell me, have you read? Okay. Let me explain what is it. Okay. See here. Like any other section, I will first tell you I will write and explain you. Okay, I will make it full screen only. You can also write down. See, some sections require full clarity. So let us write down. Section 23 of GCA. We are going to do lot of analysis now. Please participate, do it. First, point number 1. Section apply when rules or bylaws. Bylaws, rules both are same. Some acts ki rules will be there, some acts ki bylaws will be there. Okay, bylaws means one level below the law. Section applies when rules or bylaws of any act require previous publication. First, for the students, I will give one example. You can connect to the example and then we will begin. See, before taking a decision, example, we planned these classes, free classes we planned, and we are going on throughout, consistently over a period of last 20-25 days. We are going on continuing the classes. Okay, now I wanted to make a little change to the schedule, saying that rather than joining every single day, we can also have an alternative proposal wherein we will put 5 days to each subject, 5 days to full days we will take the subject. Such that 2 advantages I found in that. One, fastly we can complete everything and subject will be completed first. So if you spend time for like that, you need not extend till August 15th like that. This is an alternative plan that I got in my mind. Since I also have final classes, I don't wanted to stop the promised classes for inter. So there is an alternative arrangement made. Before taking the decision, I first asked for your approval. How many of you are okay? 100 need not say, at least 80-90 if they say, we can take a decision accordingly. Correct? Same logic. Whenever government also taking any kind of decision by making changes to the laws or bringing new law or a bylaw, you should not directly apply that. First, previously give a publication. Means what? Make the public aware. Who is affected party? Because of doing like this, who is affected party? My students are affected party. Therefore, what I should do? I should first ask them, is it okay? Is this proposal useful for you? Some people will tell, no, sir. I am having class or I am having office elsewhere. So it may not be possible for me to attend a full day. Now what I have done, I made amendment to my bylaw. What I said, no problem. If you wanted to attend, you attend live. Wherever you can't attend the live, these classes will be available for 5-6 days after live. So you can listen in bits and pieces and complete it. That is how always a person should act. Whenever one person is dependent on you, affected parties are there, you cannot directly pass a rule or a judgment against them because it will affect them. Know their idea, know their mind, know their emotions, understand it, and then take a decision. Same concept that protective care has taken by General Clauses Act. Means what General Clauses Act wanted to convey? It wanted to say that whenever you wanted to bring any law or a bylaw or a provision or a rule, etc., please don't bring that upfront directly and throw on the faces of public. Who is affected party? Public, na? First prepare a draft. Draft means a rough of the rule. Send it to them. So send it to them means I should send by post. Official gazette, if you send it, it is complete notice to everyone. If you don't read official gazette, that is his mistake. But you publish your draft rules on an official gazette. Let them read and absorb the content. If there are any changes required, make necessary changes. Prepare a final draft and publish it. That is how you need to bring a rule when it is affecting public. That's what this section wanted to convey. Means what? If power to make rules or bylaws is given, means MCA Companies Act has given a power to make the rules. MCA should not directly bring a rule. There is a procedure for that. Step 1, publish a draft of proposed rules. Okay, publish the draft or proposed rules for information of persons likely to be affected. Directors are getting affected now. They should know what rule you are bringing without asking them why you are bringing, because at the end of the day they have to follow that. So do one thing. You ask them first. Okay, what you have to do, along with the draft, a notice specifying the date on or after which draft will be taken into consideration shall be published. Means what? You first prepare a rough of the rules. Rough of the rules. Send it to all the persons, not by individual notice. Publish in official gazette. That's what they said. Publication official gazette shall be conclusive proof. Okay, publish in official gazette. Generally, directors will read official gazettes. They read. They understand, oh, new rule is coming in companies which is affecting us. Let us read this. They will read. They found some loopholes inside, some mistakes inside, some rectifications, objections are there. What you have to do, along with the draft, a notice specifying a date on or after draft will be taken into consideration. You should tell, I am not giving you 100 years time, 10 days time. If you have any objections, you tell, or else draft will be considered final. Next, publication shall be made in the manner authority deems fit. So draft publication official gazette not required. Draft publication you can send individual notice, newspaper advertisement, whatever you deem fit, you do that. Next, they raised objections. Consider the objections and suggestions. Then final one you should publish in the official gazette, which becomes conclusive. Understood? So therefore, whenever a rule or a bylaw was to be made, first don't directly bring it. Stepwise procedure. Step 1, prepare a draft of rules and bylaws. Step 2, publish it in the way in which government deem fit. Step 3, the contents inside that should also tell the last date before which objections has to be raised. Step 4, consider the objections and suggestions. Step 5, prepare a final draft and publish in the official gazette. Understood? Okay. So now question. Sir, some objections are raised. Draft is there, objections received, final is there. Final order directly I can pass. I need not again. If government wanted to do, it can do, or else directly they can make the final order and they can give. That means it is not always compulsory that before passing a final order, first they should tell to the public, these are the draft rules, these are the objections and suggestions, we made all these amendments, then this final order was passed. You need not give that much explanation to public. Over information to public is also a problem. That's why what they said, it is open to such authority to make changes in the draft before finally publishing them. Why they are making changes in the draft? They received objections and suggestions. Also, it is not necessary to republish draft rules in amended form before final issue of changes are made. If you want, you can, or else not needed. Compulsion is not there. Everyone tell ya, understood this section or now section 23, everyone? Could you now relate and understand? Bylaw means subordinate to the main law, like rules. What is the flow? See, draft rule. Publish the draft. Invite public objections. Consider objections or suggestions. Final rule or a bylaw. This is the point. Everyone, now do you understand that before bringing a rule, what government has to do? Done. So with this, we completed section number 23. So hopefully, I think everyone is having full clarity now on the discussion, right? Next. Power to issue includes power to add, amend, vary, and rescind. See, whenever I have a power to include something, I will also see. We read one section now. We have a power to appoint, means power to suspend is given like that. If I have a power to issue any new rule, I also have a power to add it, amend it, vary, and rescind. That's it. Okay. Remaining not that required here. This main sections of this particular General Clauses Act have been completed. So with this, we have successfully completed a 12 marks chapter, General Clauses Act. What is it? General Clauses Act. First of all, everyone give me one reply. Before our class, after our class, did you find any difference in your understanding the General Clauses Act or not? Everyone. Okay, that's it. That is the target first. See, it should not be like just completing, means completing for names, say half an hour la general class completed claps. This is not our intention, na? We have to complete, means you have to complete with that commitment. Everyone should understand. So half an hour for 45 minutes if you complete GCA, last moment when you cover everything, see, already GCA you read for 3 times, then 30 minutes, 40 minutes of discussion of GCA will help you. Section 23, we spent around 15 minutes time. Now, how can you understand GCA in 45 minutes? It took around 10 hours for us to complete GCA, 8 hours almost to cover GCA. How can 30 minutes we will complete? If you have complete knowledge on GCA, 3 times you read, then 30 minutes, 45 minutes will help you. Clear? Yeah. Listen, I just wanted to tell you our shift in the timings. Many people message that morning time may not be possible for them. So from now I am telling you how the classes are going to be held. This is only for the July month. August month again we will be having schedules like in evening as well. No problem, because I will tell you the reason. Everyone please listen to my words clearly, please. CA final refresher batch is there for AFM. 500 plus enrollments came by yesterday. I made one video yesterday. By that time, around 300 or 310 students enrolled. After making that video yesterday, we got around 180 plus admissions extra. So around 500 students. I think they will reach around 750 this time. Highest by any faculty in India for CA final AFM. Undoubtedly, we will publish that officially also. So 750 students for one single batch online is not a joke, yeah. So really, I take it as a great achievement, and we should work also on that in the proper way, or else our name will be gone. Bigger strength, bigger responsibility, or else we will become utter flop. So therefore, what I will do now, I said very clearly to them, since this is a paid batch, I have to be responsible. Free batch, I should be more responsible, because when I put a free batch, more number of people will take that assurance. So therefore, CA inter CA final, how I am going to manage, let me explain. Okay, without affecting both of them, I will explain. CA final, I am putting the classes in morning. See, just now we explained the example of section 23. Before taking a decision, we should inform. That's why I always inform you. I will take the consent and then we will go with. Okay, listen. CA final classes we are doing in the morning time. How I am planning na? July month for CA final. You should know 7 to 9:30 a.m. every day CA final AFM class will be there under 2.5 hours. This will be till July 31st. Why I kept like this? Simple logic. At that time, here for CA Inter, FM classes from 10 to 6 will be held. Okay, FM classes from 10 to 6 will be held. Correct? So 10 to 6 FM classes will be held. So not to interrupt this, I kept like this. Okay, so 7 to 9:30 we will be having CA final class in the morning, and 10 to 6 we will be having the FM class. Okay, point 1. So our FM classes are already logged here from 15th till 23rd. Okay, one day extra also I will be taking, no worry. FM la 50 on 50 is our target. At least if 10 students get that, that's really a greatest feather on my crown. Okay, so 10 to 6 FM class, 15 to 15, 16, 17, 18, 19, 20, 21, 22, 23. 8 to 9 days I will be taking. 10 to 6 or 10 to 7, whatever the case may be, no worry. We will complete everything there. Okay, once I complete that, then what I will do now, capital budgeting la we will have the session separately for 2 to 3 days where we will do extra 20 questions on that. Okay, so 15 to 23 locked FM over. Next, sir, what about law? Immediately after that, we will anyway have the law from 28, 29, 30, 31 or 27, 28, 29, 30, 31. So 27 to 31 law 100% will be completed. In that, what we will do, 2 days, it's every day 2 chapters we will take. Morning 10 to 6. Morning 10 to 6 or afternoon 1 o'clock we will start, up to 7 or 8 we will take. Timings I will tell about that very clearly. So law we will be taking it. How we completed GCA now? Like that, every chapter I will complete. Then we will do the question bank discussion. Perfect. So 27 to 31 completely we will focus on law. So some people may not attend live. At that time, I will be putting also the video on YouTube and I will make it available for 5 to 6 days. They can listen. Next, with regard to the DT, as I said, once a law is completed, we'll start with the DT directly. DT discussion will be for 5 days. Okay, which will not interrupt CA final, because from August 1st onwards, CA final classes will be from morning 7 to 12:30. So what we will go with the DT, what we will do with the DT class? DT class will start at 2 o'clock in the afternoon till 9 o'clock I will take, such that 6 hours of effective time, 7 total hours, breaks half an hour if you take, 7 hours, 6 hours of effective time will come, and we will cover all the big chapters during that time frame. 6 or 7 days, 5 or 6 days we will take, and we will complete DT also 100% there. At any cost, by 10th of August, we should start with our test series and revisions. How many revisions? Each subject 3 revisions we have to do. Law 1 revision I will do. 1 revision you will listen again. Okay, finally before exam we will do 1 revision. So this is how we are going to do 3 revisions with regard to all the 3 subjects. Okay, wow. So first of all, everyone, tell me, did you understand the schedule clearly? Yeah. And what I wanted to tell now, today onwards CA final, today demo class will start in another half an hour for CA final students. So since pressure will be mounted also on me, so I will be now transferring the morning time completely to CA final. So summary I will tell you. From now, morning class is shifted to CA final. CA inter, we will be having classes in 3 blocks. Okay, 3 blocks. Block number 1, FM, first we will complete, next law, next DT. FM I told you the schedule already. Then we will go to law and DT. In law, the good thing is there is general meetings chapter which are completing, big chapter. We completed another big chapter, GCA. We have already completed dividends. We have already completed preliminaries to Companies Act. All these are already completed. So small chapters will be there with the 2 big chapters. Okay, so law is never a problem for us. We will complete it. 27, 28, 29, 30, 31 we will complete. The only concern for me is DT, because we have to cover DT in a proper way, not just like revising 2 days and completing it. So I will be taking DT on a daily basis, but in the month of August, 5 days is there now. In that 5 days, what I am going to cover now? Salaries, house property, deductions, set off, carry forward, and clubbing. These all I will complete in that day. After that, we will put PGBP. PGBP you are listening in anyway. On the total income questions, we will be doing on a daily basis. Okay, evening time. Evening time I will be free. So evening time, what we will do now? We will take total income question. 2 or 3 total income questions we will do every single day till September, such that your confidence will be boosted like anything also for DT. Okay, see, listen carefully. I am telling you as a summary. We are not going to compromise it any cost. Timings there will be changes. Please adopt according to the requirement. Okay, hopefully you can understand. Year final is a paid batch. We can't take any kind of chance on them. Okay, reputation will get damaged. So that does not mean I will put the second priority on CA Inter. Equally prior. That's why we are putting a block type of classes and we will complete. After that revision time, wherever you did not understand, we will take those chapters. Everyone clear? Huh? Okay. So whenever evening class is there, I will inform well in advance. One day before I will announce. Okay. Today if DT class is there or not, I will tell you the evening whether the class is there or not. Okay. If it is there, I will tell you in advance. By somewhere around 12:30 like that, I will announce you can join. Okay. So this is what I wanted to just convey to you before taking that decision. Okay. So tomorrow morning classes will not be there. Yeah, morning classes shifted to CA final. Evening class, whether it will be there or not, I will tell you, because I have lot many schedules in my mind. I will tell you tomorrow that I will tell you, at working capital balance also I will upload. Yes, array that Triop series is there now. I am extending till 13th. Okay, no worry. You can listen. You can extra 3 days I will give. Your listening is my point. Yeah, my point is not to just make it private. My intention was, if I don't make it private, you will procrastinate. You will prolong that. You will not listen. My problem is not to give. Right? That is the reason why I have to take a free class. That's not at all a problem. My point is, even after these many things, why you delay doing things? That is my question. Why you don't put studies in priority before all other things? You should put this as a priority. Okay, so thank you very much. We'll meet again. I will tell you when our resumption of classes will be there. Please don't lose what to say, that continuity with regard to dividends, with regard to General Clause Act, with regard to the preliminaries of Companies Act, with regard to the general meetings. Please do the question bank. Okay, GC also next session I will take a question bank discussion 100%. Okay. Okay then. Thank you very much. Thank you. Take care. Factoring notes I will send.